designed and intended by Ms. Heard to imply a defamatory meaning. Designed and intended to imply defamatory meaning. The two statements on domestic abuse in the op-ed, and Your Honor's well aware of the ample Virginia case law talking about how you have to view the op-ed as a whole, you have to view words in context. So these are the statements that read, then 2 years ago, I became a public figure representing domestic abuse. And then the other statement that says, I had the rare vantage point of seeing in real time how institutions protect men accused of abuse. Now, those statements are entirely opinion, except for, according to Mr. Depp, the discussion of domestic abuse. So the statement, I became a public figure representing domestic abuse, and the statement in the second sentence that Mr. Depp was a man accused of abuse. The rest of those are inactionable opinion statements. Now, the evidence adduced thus far, Your Honor, shows that Mr. Depp can't sustain a claim on these for two reasons. First of all, the statements are true on their face. I don't think that there's any dispute about that, and that's been the subject of some testimony in this case. 2 years before she wrote the op-ed, Ms. Heard did, in fact, become a public figure representing domestic abuse when she obtained a domestic violence restraining order against Mr. Depp, and Mr. Depp was indeed accused of abuse. Those are facts that are true. Now, to the extent that Mr. Depp will argue that he's proceeding on a defamation by implication claim, again, the court should disputed evidence is that he did, in fact, abuse Amber. Now, there's a dispute in this case. There's ample evidence that he physically abused Amber, but we acknowledge that there's a dispute in this case on that. But what there isn't a dispute in this case is non-physical abuse. Both Mr. Depp and his expert Shannon Curry have testified that abuse may come in many forms. It may be physical, certainly, but it may also be verbal, may be emotional, may be psychological. Physical abuse that he allegedly suffered at the hands of his mother, he said it was worse than the beatings. And the example he gave was that his mom used to call him One Eye as an example, because he had a lazy eye, I guess, as a child. That was something that Mr. Depp himself said was abuse, his mom calling him One Eye. So, setting aside the evidence of physical abuse in this case, which is already overwhelming, Mr. Depp's claims relating to these two statements should be stricken because of the ample and undisputed evidence in the record of non-physical abuse by Mr. Depp toward Ms. Heard. There's evidence in the record of recordings, messages, including messages written in blood, with his finger, blood and paint, vile names, shouting, menacing and threatening statements. There's the video, the kitchen video in Sweetser. There's the audio of him calling Ms. Heard, like I say, numerous vile names. There's the audio of him asking her to cut him, and whether she wanted to be cut. So there's plenty of evidence out of the words or out of the mouth of the plaintiff in this case that constitutes non-physical abuse of Ms. Heard. Again, under the standards set forth by his expert and the plaintiff himself. Those are Depp abused Ms. Heard physically, verbally, emotionally, or psychologically even one time, then she wins on those claims. Then she wins. It's that simple. And the evidence is overwhelming and undisputed in the ways that I've just described that he did. So for that reason, Your Honor, those claims should be stricken. And I'll just cite the Union of Needle Trades versus Jones case. This is 268 Virginia 512 that states, if the plaintiff does not establish the falsity of the statement by a preponderance of the evidence in his case in chief, he has not met his threshold burden, and the trial court should strike the evidence and grant summary judgment to the defendant. That's exactly what should happen here. The evidence is established that Ms. Heard didn't write the headline. Mr. Doherty from the ACLU, that's the only evidence that's come in this case thus far. And plaintiffs control the evidence.
Well, I understand, but there's also a stipulation that Ms. Heard would not be called in the plaintiff's case because they would then use her testimony for part of their case in your case, right?
That's correct, Your Honor.
Yeah, I agree, and that goes to a different issue that I'm not arguing. I'm not arguing that the court should strike because they haven't put Ms. Heard on to testify about the headline.
But I assume part of that would be that they would, I guess they intend to get from Ms. Heard is that she either wrote it or republished it.
Yeah, what happened the next day is Ms. Heard posted it on her Instagram account and said, look what I published yesterday in the Washington Post. So she adopted the title, and her name was on the article which contained the title.
And Mr. Ronborn, the only reason I'm sorry to
No, that's
interrupt
fine.
you,
Of course.
only, because I know that was a stipulation, so it's hard for me to say that that's all the evidence for motion to strike if there's a stipulation that they're still going to get more evidence in on that particular issue.
I think, and I'm happy to hand the court the transcript of the April 8th hearing, because one of the things that we're not arguing today is that because they haven't put in evidence of I think it was a tweet, but Mr. Chu says it was Instagram, I don't know, whatever it was, that because there was...
It was a tweet adopting the op-ed she published the day before the Washington Post.
Okay.
All right, so what I'm not arguing today is that because they haven't gotten that tweet into evidence or had Ms. Hurd say that she tweeted that we're entitled to summary judgment at this point. I'm not arguing that, but that's all that we discussed on April 8th, and I'm happy to hand the transcript up to Your Honor. And we actually never, it wasn't a stipulation, it was simply an agreement that they didn't need to call her in their case to make that point. And then Ms. Bredehoff said, we'd have to agree on the language of any stipulation. They haven't proposed anything to us and haven't gotten back to us. So I think that that's only relevant. We're not basing our request for motion to strike here on Ms. Hurd not having testified to sending that tweet.
But you're saying for the motion to strike, the only evidence before the court is that the Washington Post wrote that title.
Correct, and that's very different from what happened the next day. The stipulation didn't go toward who wrote the title. That was never part of anything, and it's undisputed. And Ms. Hurd will testify that she didn't write the title.
Well, I understand that,
But
I think
it's not undisputed, Your Honor. I apologize for interrupting.
Okay. But I think the issue is that whether it was republication.
Well, and I'll get to that next.
Right, I know, but the problem is, how do I do a motion to strike when that evidence isn't before me yet?
Well, the republication isn't. So the evidence that's before you is that the Washington Post wrote the headline, or that Ms. Hurd didn't, and that's the only evidence, and that's not going to change. The tweet, which was the only subject of the discussion of the pre-trial conference, where there was no stipulation, it was just an agreement that we're not going to base a motion to strike on them not introducing evidence of the tweet. That was what it was. So, as under the Lakova case, 995 F3rd 134, in that case dealt with hyperlinks and how those aren't actionable. But to be very clear, nothing that was discussed on April 8th, nothing that was discussed at that pretrial conference was in any way relating to any stipulation about who wrote the headline. It was simply that they need not call Ms. Hurd in their case in chief to get her to say that she sent a certain tweet. And that tweet's not in evidence yet, but I assume that they'll try to put it in evidence at some point. But the tweet doesn't need to be in evidence for you to strike this claim on that basis. Mr. Depp hasn't introduced evidence sufficient to permit him to meet this. Now, again, this is a heightened burden of proof. He has to show actual malice by clear and convincing evidence. And as the and on that evidence, there cannot be a conclusion that Ms. Hurd acted with the actual malice that's necessary, particularly when you consider the heightened burden of proof. So reviewing the op-ed as a whole, with the court acting in its appropriate function as a gatekeeper of the First Amendment, we ask that the court strike plaintiff's evidence and award summary judgment to Ms. Hurd, either in whole or in part. Thank you.
All right, thank you. Yes, sir.
May it please the court, Ben Chu for Plaintiff Johnny Depp. It's just still morning. Your Honor, if I may approach. I've just handed to Mr. Rottenborn and Your Honor an opposition that we prepared before we had the benefit of seeing Ms. Hurd's affirmative motion to strike, that I think we've anticipated the arguments made, such as they are. The court should deny defendant Amber Heard's motion to strike because Mr. Depp has come forward in his case in chief with multiple credible witnesses, documents, and authentic tape recordings of Ms. Hurd herself, not only satisfying all of the requisite elements of his claim for defamation, including actual malice, but also going the extra mile of showing that Ms. Hurd physically abused him. She's the abuser in this courtroom. Your Honor, going back to the standard, as Your Honor is well aware, in considering a motion to strike, the trial court must view the evidence and all reasonable inferences drawn from the evidence in light most favorable to the plaintiff. Any reasonable doubt as to whether the plaintiff has produced sufficient evidence of the wrong alleged must be resolved in the plaintiff's favor and the motion to strike denied, unquote. In deference and respect to the court's time, Mr. Depp incorporates by reference the legal analysis set forth in the court's opinion letter dated March 27, 2020, overruling Ms. Heard's demurrer to the 3 defamatory statements at issue. And that letter opinion is attached as Exhibit 1 to Mr. Depp's opposition. That's where the court fulfilled its proper gatekeeping role that Mr. Rottenborn referred to. The elements of a defamation claim are the following: publication of an actionable statement with the requisite intent, citing the Shaker versus Bonfalk case 290 Virginia 81 and 91. As to damages, they are presumed here because Ms. Heard's false allegations of domestic abuse, sexual assault, and rape constitute defamation per se, citing the Tronfield case 272 Virginia 709 713, a 2006 case. As the court noted at page 3 of its opinion letter, typically an editorial or op-ed column is ordinarily not actionable because it appears in a place devoted to or in a manner usually thought of as representing personal viewpoints. However, Virginia recognizes that, quote, a defamatory charge may be made by inference, implication, or insinuation, citing the Carwell case. And a statement expressing a defamatory meaning may not be apparent on its face, citing Pendleton, with which the court is quite familiar. Based on the authority and reasoning set forth in pages 4 through 8 of the opinion letter, the 3 statements at issue are actionable under a theory of defamation by implication. Mr. Depp established in his case in chief that Ms. Heard, in fact, made all 3 of the defamatory statements at issue. As the court admitted into evidence as Plaintiff's Exhibit 1, the op-ed Ms. Heard published in her own name in the Washington Post on December 18, 2018. And let's take the 3 statements and the proof that has been adduced. Statement number 1, Amber Heard, quote, I spoke up against sexual violence and faced our culture's wrath. That has to change. Per page 6 of the opinion letter, the first statement could reasonably convey the alleged defamatory meaning, i.e. that Mr. Depp abused Ms. Heard, to its readers without extending the words beyond their ordinary and common acceptation. See Pendleton 290 Virginia at 172, also citing the Carwell case. Resolving every fair inference in Mr. Depp's favor, this statement could reasonably imply that the sexual violence Ms. Heard spoke up against was in fact perpetrated by Mr. Depp. Mr. Depp produced several credible witnesses and documents proving that Ms. Heard was implying that he committed sexual violence against her. Mr. Depp himself testified to that, as did his sister, Christy Dombrowski. Mr. Depp's former agent, Kristen Carino, testified that, as did his current agent, Jack Wiggum. But perhaps most convincing of all, and most disgusting of all, was the testimony of the ACLU's Terrence Doherty, a lawyer nonetheless. Mr. Doherty testified, among other things, that when they were pitching the op-ed to the Washington Post, they stated, hey Michael, wondering if we might interest you in a piece by Amber Heard, who, as you may recall, was beaten up during her brief marriage to Johnny Depp, on what the incoming Congress can do to help protect women in similar situations. Mr. Doherty also testified that everybody understood, as Ms. Heard and the ACLU clearly intended, that this statement and the other 2 statements referred directly to Mr. Depp. Quote, Your Honor, there is Ms. Schulman, also of the ACLU, acknowledged that Ms. Heard's op-ed referred to Mr. Depp. No one would have been interested in anything written by Ms. Heard. Mr. Doherty also testified that Ms. Heard only paid 1.3, actually she didn't even pay all that, out of the $3.5 million that she had pledged to the ACLU, and then they helped her lie about it. And it's one thing, Your Honor, for her to stiff the ACLU, which frankly played a reprehensible role in this case. It's quite another for her to fail to honor her obligation to the Children's Hospital of Los Angeles with sick and dying children. And that she failed to do as well. And as Your Honor has mentioned, the fact that she put her name on that article means that she is responsible for all of those statements, which she specifically adopted later. And I'll go through the other two statements quickly, Your Honor.
Well, can we stay on this one for one moment, though?
Yes, Your Honor.
Because do you agree that the only evidence before that we've heard in this trial, as far as the title of the op-ed, is that even Mr. Doherty, I believe, testified to it, that it was something that Washington Post wrote?
Well, I want to come back later and say, gee, she didn't write the title, as if that were a defense. I hope they make that argument. I hope they make that argument to the jury, because it's about as credible as her argument that, oh, I wasn't referring to Johnny Depp. She didn't have to. And the testimony of Terrence Doherty was very clear that when they took out the references to Johnny Depp, no one was interested in this article anymore. So she said, put it back in, make it more spicy so people would read. Otherwise, she couldn't get it in the Washington Post. It would be back in Teenage Vogue, which is the other publication that was considering publishing it, because no one was interested in what she had to say unless she was defending Mr. Depp. But if I could go to the second statement, I'll try to be quick, Your Honor. 2 years ago, I became a public figure representing domestic abuse, and I felt the full force of our culture's wrath for women who speak out. As for the second statement, defendant called herself a public figure representing domestic abuse, which can be read to imply that she became a representative of domestic abuse because she was abused by Mr. Depp. And his grandmother testified that Ms. Heard was referring to her bogus ex parte TRO that she obtained on May 27, 2016. And it was interesting that Mr. Depp's own lawyer said that she wasn't even provided notice. So Ms. Heard made very sure that Mr. Depp wouldn't have notice of the ex parte TRO. And Ms. Heard herself, the evidence shows, knew that Mr. Depp, having just suffered the loss of his mother, was already on the other side of the country. He was already in New York at the time of this TRO and was heading to Europe for several weeks. So she knew she didn't need any protection from him. The $7 million in the divorce settlement that she said she gave to the ACLU, she swore she gave to the ACLU and the Children's Hospital of Los Angeles, and she pocketed instead. And the inimitable Mr. Doherty of the ACLU, which lent its once respected name to Ms. Heard's defamation. It matters not how artful or disguised the modes in which the meaning is concealed if it is in fact defamatory. A sworn denial is all he needs to survive a motion to strike. But there's a lot more than that, Your Honor, and I'll try to be brief. 3 police officers, actually 4, but the 3 who testified already, Officers Sines, Haddon, and Gatlin, testified unequivocally that Ms. Heard did not have a mark on her on the evening of May 21, 2016. And I could go through, I'll just go through very quickly. Officer Haddon, I did not. Question, okay, were you looking to see if she had any injuries on her at the time? Officer Sines, yes, I was. Question, and so you were looking to see if Ms. Heard had any injuries and you determined that she did not. Is that accurate? Officer Sines, correct. Last time Mr. Depp saw her before leaving on the Hollywood Vampires tour, the next time he was to see her was when Ms. Heard begged him to come see her in San Francisco, which is hardly the act of a domestic abuse victim. Ms. Heard's former personal assistant, Kate James, and several other witnesses, including Dr. David Kipper, saw no violence by Mr. Depp and no injuries to Ms. Heard. Indeed, witness after witness has come forward to testify that Ms. Heard, far from being a domestic figure representing domestic violence, unquote, is in fact a recidivist perpetrator of domestic violence on Mr. Depp and others. We have the testimony, the harrowing testimony of Mr. Depp himself, who described several witnesses. One, and she claims to have hurt her foot kicking the door. Mr. Depp opens the door to see if she's hurt, and then she kicks the door in on him and punches him. We have the incident of December 15, 2015, when Ms. Heard threw punches at him wildly at the back and side of his head. Mr. Depp testified that he ducked and covered to protect his face. Eventually, he turned around to grab her and stop her arms from flailing. We have testimony from Mr. And by the way, Tara Roberts, who is the manager of the island, confirmed that the incident with the mineral spirits. You have Mr. Depp's testimony of what happened on April 22nd, 2016, and we've heard